Hello, my name is Sailesh Mehta. I'm a barrister. I'm head of the Red Lion Chamber's fire law team. It's my pleasure to introduce you to Colin Todd MBE, who is the Managing Director of CS Todd and Associates today. The purpose of this series of webinars is to look at specific legal cases, to look at some of the details of those cases, to extrapolate some principles from those cases, and then to see if we can apply them with my guests to a wider range of scenarios. And Colin Todd is particularly suited to assist me to do that. Colin and I have worked in conjunction with each other on cases as well as against each other over the last few years. Colin is a well-known expert. He's recently received a Lifetime Achievement Award by the Fire Industry Association. He's also an expert in the Grenfell inquiry, and of course he's a veteran of many criminal and civil cases. So without further ado, Colin, the aim of this conversation is to look at one or two of the cases that you and I have been involved in. The first such case is a case involving 3 fatalities, the St Michael's Hospice case.
Yes.
That's a case which I was prosecuting and you were advising and assisting the defence.
Yes.
In that case. And if I can just start off with a few sentences of background. This is a fire in a hospice that took place in July 2015. Within 24 hours of the fire, 3 of the residents had died. 2 of the deaths were directly connected to the fire by a pathologist who reported shortly after. The fire was lit on purpose, it turned out, after a police investigation and an arrest, in fact, of one of the residents who passed away, sadly, shortly afterwards. But it's what happened after the fire took hold, with the use, I think, or the assistance of hand gel nearby and oxygen cylinders that were lying nearby. It's the reaction of the staff, the fact that doors had been locked that couldn't be opened, the fact that beds could not be moved through corridors and into safe places. So it was a disaster waiting to happen. Now, Colin, just broadening the subject to expert evidence. Now, you're aware, Colin, that the prosecution that I led had their own expert. What's your view about when an expert should be instructed and why an expert should be instructed?
Yeah, I think the earlier the better. In the same way as when prosecution proceedings have some potential, you need to get hold of a lawyer as soon as possible. And the earlier the lawyer is instructed, and then the lawyer will probably want the assistance of an expert. The earlier all of that happens, the better. And that's true whether the expert's acting on behalf of the prosecution or the defence. In terms of the why, in the case of the prosecution may need some expert assistance in determining what breaches had occurred and what offences arose from those breaches. In terms of the defence, it's important to make sure that the client is properly advised on responses to, for example, a request for a PACE interview. The expert has to be quite careful not to become involved and sucked into the investigation, and there's a fine line there. But the role of the expert, of course, as you know, Sailesh, is to advise the court, regardless of whoever has instructed them. But so it's quite important to maintain a distance and impartiality throughout the whole process. Otherwise, ultimately, if you've become part of the investigation, you can't then act as an impartial expert for the court.
Colin, as you know, when I am instructed as a prosecutor, I often find it very useful to talk to an expert, particularly if one has been instructed at an early stage, before I finalise the summons and the indictment. Can you give an example of when the line might be crossed between using the expert as a sounding board at that early stage and when the expert crosses that divide line?
Yes, there was a case involving some fatalities in a hotel, quite a high-profile case at the time. And it's a matter of public record because it was acknowledged by the Fire and Rescue Authority in conferences afterwards that I assisted them in the investigation to the extent that I discussed the possible offences and the breaches and the articles in question. And so when it came then to the court proceedings, I couldn't act as their expert witness. Otherwise, I would be effectively giving impartial evidence on the veracity and validity of the charges that I'd helped them frame in the first place.
Exactly. So you effectively been reporting on the very matters that you thought were quite a good idea to prosecute.
Yes, I'd have to ask myself was my advice to the prosecution correct? Obviously it needed then another expert to act as the expert witness in the prosecution proceedings. So that's a case where, as you put it, the line was crossed. Everyone recognised the line was crossed, and I couldn't act as an impartial expert, having effectively assisted in bringing about the prosecution proceedings.
Okay, thank you. Back to the St Michael's Hospice case. You're aware, and the court was aware, that the prosecution had its own expert who, in fact, was not independent in speech marks, in the sense that it was an expert who was involved in the case itself. What are your views about independent experts and those that are employed by fire services?
Yeah, I think you have to be very careful. I'm not sure you and I actually saw eye to eye in that particular case as to how an impartial expert could also be the investigating officer and the family liaison officer, but the court obviously accepted that, and it's not for me to disagree with that. But and there is nothing wrong in principle with using a fire and rescue authority using its own expert who is an employee of the fire and rescue authority. I think you would agree it's probably best, though, that there be blue water between that in-house expert and the investigating officer in the case, and that happens, I think, with HSE quite a lot. You'll find that HSE field an expert witness, but the expert witness has had no involvement in the investigation in the first place.
And so you're right that the court found nothing wrong in principle, but it was after a long, hard-fought battle. The defence had run an abuse of process argument on the basis that the prosecution expert was also one of the main officers in the case, had been involved in the investigation, and was also liaising with the family. I think what assisted the prosecution case was that expert was a very senior officer. In fact, he went on to become, I think, the chairman of the IFE, and at the moment is advising the national chiefs. So his seniority, I think, must have assisted. But I suppose, Colin, the standard point is, if it's a bog standard case, the common or garden magistrates court type of fire case, then in principle nothing wrong with an officer, in-house officer, being the expert. But if it's a more serious case, then consider perhaps an officer from another brigade who can show independence. And if it's a really serious case, such as a fatality, then I suppose the starting point should be, unless there's very good reason not to instruct an independent expert such as yourself.
Yes, or if there are some significant technical issues. I'm not sure there always has to be a fatality. There are some very high-profile cases where, in which I've been involved, in which either there was a fire, but no one as much as cut a finger, and I acted as a defence expert witness, or indeed there was no fire, because, of course, there doesn't have to be a fire in order for offences to be committed. They might just fall out from natural routine audits.
Okay, back to some specifics. So the expert gets instructed in a case like St Michael's Hospice. And one aspect of the expert's report is to see what breaches have taken place, if any. Is that the starting point?
Yes, I think I always see it, Sailesh, as there are three hoops on which I need to advise if in terms of the validity of the prosecution. So the first hoop is, has a breach been committed in the first place? And that's not always as black and white as it seems, because as you will know, the physical fire precautions specified, required under the fire safety order, need to be provided where necessary. And that necessity has to be tested in order for there to be a breach. Then, of course, there is what was originally known as decriminalisation of minor breaches. So in order for an offence to be committed, there has to be the risk of death or serious injury in case of fire. And again, Sailesh, I think you'd agree there's a little line there that you need to be careful about, that it's not the role of the expert to determine whether an offence has been committed. That's the role of the courts. But the expert can give technical advice as to whether there was risk of death or serious injury. And then, having established that, there is a third test that is probably worth investigating in most cases, although it will normally not come to anything, and that is there a due diligence defence? So enshrined in the fire safety order is the defence of that if one took all reasonable precautions and showed all due diligence to prevent the commission of the offence, that is an adequate defence, unless the alleged offence is putting employees at risk of death or serious injury in case of fire, in which even the due diligence defence is not permitted. But that's always worth testing. But you will know how well legal counsel will always stress all due diligence and all reasonable precautions. So provided you can find some reasonable precaution that might have been taken to prevent the commission of the offence, then the due diligence defence doesn't fly.
Yes. Coming back to the second of the three hoops, Colin, the risk of death or serious injury. When I defend particularly, my experience is that some brigades tend to over-prosecute, by which I mean rather than one overarching summons, you find there are 10 that deal with specifics, such as this way to escape route signs missing, that sort of thing.
Yeah.
Is there a connection between splitting up an overarching summons into these individual points and then perhaps risking whether each breach results in the risk of death or serious injury?
Yeah, I think there's two aspects to what you just said, Sailesh. One is some fire and rescue authorities see it as a numbers game, and the more breaches can be alleged, the better. Possibly the classic case, and I think this is in the public arena, the New Look prosecution, which at the time resulted in the highest fine in history of fire safety legislation, started off with 35 alleged offences. And the judge said he wasn't prepared to listen to 35 offences. Come back when you've got it down to 10 and possibly substantially less. And it ended up as 2, of course. So that's the first thing. The second thing is there is a tendency for fire and rescue authorities to assume that it's a bit like speeding, which is near to my heart at the moment because I'm being prosecuted for doing 25 in a 20 area, which I thought was somewhat puerile. However, there is an assumption that every minor breach must constitute an offence, and in order to establish the offence, the breach is described in the charges followed by a comma, thereby resulting in the risk of death or serious injury in case of fire. And I think you mentioned signs a moment ago. There was a case in which 3 charges were brought, 3 separate charges, because fire exit signs didn't include the running man, comma, thereby putting relevant persons at risk of death or serious injury in case of fire. And as a defence expert witness, my view was, well, the client needs to put their hands up to some offences here, but certainly not those three, which eventually did disappear.
Yeah. And so one of the key things that a defence expert can assist with is that even if there is a technical or a real breach of one of the articles, it doesn't necessarily follow that that results in an offence.
No, that's a really important point to establish, and of course a very moot point. At what point does a breach become so serious as to put people at material risk of death or serious injury?
Yes. May I move on to another case, Colin, that you and I have been involved with? That's the case of Alan Foster. That was a prosecution in Yorkshire following a fire in which two youngsters, very promising young jockeys, died. They were trapped in a room. And one of the uses that an expert has for the court really is to assist in the sentencing process, to assist the court with an expert's report on how far below the appropriate standard the defendant fell. And that's again a case that you were involved in, I think.
Yeah, this time on the same side as a prosecution expert witness. And yes, I mean, sometimes the instructions to the expert from either the prosecution or the defence is to give the court some sort of feel as to how far from the reasonable standard the defendant fell, because for the prosecution point of view, then this may help with sentencing, but it also may help the defence in a mitigation report. And sometimes experts are instructed, even when the defendant is happy to plead guilty to all the offences, to produce a mitigation report on the technical issues, not on the issues that a barrister would better deal with in terms of the record of the defendant and so on. But what was, for example, fine, there was material risk of death or serious injury in case of fire, but how likely was that actually to materialise? And to what extent was there such exposure?
Yes. And in fact, that case resulted at the time in the longest prison sentence in a fire case, I think, and that was partly because of your expert report in assisting the court.
Yes, it was at the time the longest custodial handed out, and that was with discount for a guilty plea and some other circumstances that the court wished to take into account in relation to the defendant and his past help in a legal case.
Yeah. So far, Colin, we've talked about two cases, and of course all the details are in the public domain, so there's no difficulty in discussing these. I'm just going to move on to a third case, which still hasn't been litigated in court, but I just wanted to draw out a particular principle. It's a case that I think your colleague from CS Todd Associates is involved in. It involves a warehouse where there was a prosecution, and the prosecution still continues. And one of the things that you and your colleague highlighted in the prosecution case was that there was an audit by a senior fire officer. And the result of that audit, according to the fire brigade itself, was that most of the matters they then prosecuted about were not picked up in the audit, or were seen to be relatively minor. And that's something that you and your colleague picked up on to assist Defence Counsel, myself.
Yes. I mean, ultimately, of course, the responsibility for fire safety in premises rests with the responsible person. And so I think often defendants want you to take the view, well, the fire authority should have picked this up, Fire and Rescue Authority, and they didn't pick it up. But that is not, of course, a defence, because the responsibility rests with the RP. But it might well be mitigation, sometimes significant mitigation, because it might well be argued that, well, yes, fine, there were these breaches, there were these offences, but they can't have been that obvious to the RP because even an experienced fire safety officer didn't pick them up. The counter-argument, of course, is that an audit only samples, whereas the RP and the risk assessment needs to be a lot more thorough. So the fact that let's move away from that case, but let's say there was a problem on the 5th floor of an office building and the Fire and Rescue Authority chose to sample only 3 floors because the management standards seemed fine and they didn't go on the 5th floor. There's no liability on the part of the Fire and Rescue Authority, and there's no defence for the RP that the sampling process by the Fire and Rescue Authority didn't pick that up.
Thank you very much for that, Colin. Can I then move on to a very fundamental question about instructing experts? How does one go about choosing the right expert for the right case?
Whoa.
The reason I ask this, if I can put it in context, is I've recently prosecuted a case, and I'll need to be a bit careful because it's now gone to the Court of Appeal. But one of the criticisms that the defence made of the case I prosecuted was that my expert, who in my view was seen to be one of the best experts in the country on risk assessment, had not himself carried out as many risk assessments as one of the defence experts, who apparently had carried out thousands of them, whereas my experts had only carried out about 10 or 15 of them. And that was alleged to be a big difference. As it happened, the jury didn't find that to be a big difference. They convicted, but as I say, it's in the Court of Appeal. So that's by way of example of how one side might view the expertise of the other.
Yeah,
how should one?
I think most experts would be very honest, I think, if approached. And I know ourselves, we probably turned down as many expert witness cases as we then proceed with, and we proceed with an awful lot. We either turn it down because they're on a hiding to nothing and we can't help them, but more commonly it's because it's in some particular field that I can think of somebody much better. There was one particular case, it was a civil case, and the claim was like a telephone number. And I said I could get by with something like this and advise. And if it were a £5,000 claim in the county court, I'd probably say, yeah, I can probably manage. But I said for a £100 million claim, you don't want someone who can get by. You want not just the country's leading expert, but probably the world's leading expert. Actually, the case didn't go well because the expert actually appointed came in for severe criticism from the judge. And that judgment lies on the web to this day, in which the judge said, unusually, this is a case in which I cannot rely on the reports of any of the experts, which is really quite stark. And of course, you expose yourself to that if you go beyond the scope of your own competence, and you shouldn't really be doing that, and you leave yourself quite exposed. And of course, under the criminal procedure rules, you have to specifically acknowledge in your report, this is a requirement, that you are aware that if you have not abided by the criminal procedure rules, and that could be straying beyond your own competence, you may be publicly criticised by the judge.
Colin, we're fast running out of time, and so I'll make this the last question or the last point. It's about trends. The latest case law on expert evidence strongly suggests that judges, particularly in criminal cases, should take hold of both sides' experts and make sure that all of the rules are abided by, and that the aim of the expert evidence is to assist the jury in their task. And there's been quite a lot of criticism in a wide range of fields beyond fire of experts. What do you see as the future of experts and expert evidence in fire cases?
Yes, I think there will be a need for it more and more. not least because prosecutions, I think, are increasing in England, not in Scotland, interestingly enough. But I think there probably is more need for expert evidence and for the experts to get together and make life easier for the courts by narrowing the issues. And courts really appreciate that, don't they? In fact, instruct it. So I think courts do appreciate not having to get involved in technical areas when, in fact, there might well be agreement between two experts as to the issue.
We'll watch this space. Colin, we've run out of time. I could talk to you for hours on end. And in fact, each of the three cases that we've looked at in brief, we could easily do an hour's webinar in detail. And so that just leaves me to thank you, Colin, for taking part, and also to thank those that are watching this webinar. But may I just say a word or two about the Fire and Risk Management Journal. It's the UK's market-leading fire safety journal, published 10 times a year. It's available exclusively to FPA members in both digital and print format. You've been watching myself, Sailesh Mehta, and Colin Todd, and thank you very much for watching.